So this is the second part of my interview now that we've gone over what she does and how she uses mechanisms of intercommunication in the US Attorney's Office. The first question is, my instructors and others have said that language or lexis develops according to the needs and function of the community. Language might also develop to determine who the insiders of a are in a community and to keep the insiders out. Do you agree with either or both of these statements?
Um, yes, I agree with both of them. I think language, I guess, coincides with knowledge, and even though it's a cliche term, it is power. Um, if you don't understand what someone is talking about, it's a method to exclude you. That that's one thing that we go over with law enforcement officers or whatever police officers when they are testifying in court. We tell them don't use cop terms or legalese. You need to talk to the jury in plain sentences and plain words. When you're in a certain profession, sometimes you use terms so frequently that you don't realize that they're not normal terms. Um, for example, when I'm speaking in court, out and I say something that I don't mean to say, the first thing that you say is strike that. Um, when I'm talking in a conversation to my mom or to my husband or my sister, for example, and I say something I don't mean to say, I'm not going to say strike that. I'm like, wait a minute. I didn't mean to say that. This is what I meant. But in court, you would say strike that. And someone sitting in the gallery or someone that's not a lawyer may not understand what that means. So yes, it can be a method of exclusion. If someone doesn't know what you're talking about, it's easy to pull the wool over their eyes, and to pull fast ones on them, and it's easier to keep them excluded from your group.
And so how would you say that how do you say that the needs of your workplace discourse community explain the textual genres that it may use?
As far as explaining the words that we use, it depends on where we are. If I'm arguing a motion in court, which means it's just me, the defense attorney, and his client probably, and then the judge, I don't have to explain my textual genres. I don't have to sit down and explain legalese, shall I say, words that are only used in the legal community, because everyone in that courtroom is expected to understand what I'm talking about, or at least the people that are making. I don't understand how you can't prove the case if the police arrested someone, and then you have to break down to them the difference needed for someone to be arrested versus what is needed for to prove someone guilty um, at trial. And you just do your best to people and let them know that there are different standards of proof, different burdens that we have to prove for an arrest versus I'm trying to think of other times that situations like that come up. Some in court, you may not know what to be able to ask means. For example, once I was doing done, and apparently when a photo lineup is done, there's two ways you can do it. You can do it simultaneously, which means and the witness will be looking at the all six photos at the same time, or you can do what's called a double flip to the next photo. And the question was asked because I was talking about a photo lineup um, that was done simultaneously, was asked, should it be allowed into evidence because it wasn't a blind photo lineup. I didn't know what a blind photo lineup was. Um, what is a blind photo lineup? So it could be explained to me. So then I
So there is no fear, and when you are in court, you can express a need to ask if something you don't.
asking you, then yes, you can ask for it to be clarified. Um, judge, like if an objection is made and it's uh, the courtroom at that point in time is not the proper venue to ask about why a certain ruling was made. That's something that has to be asked later on when the case is over and done with.
Okay, now same question, but how would you say that your workplace discourse community explains the mechanisms of intercommunication?
To who? To the outside world or to us?
Both.
To us, we have meetings. I think I said in part one that we have, as sections, we have monthly meetings with the chief state attorney, the state attorney for the Ninth Judicial Circuit, and he explains to us what is expected of us individually and as a section as a whole. And then we let him know what's going on in our section, in our individual cases, problems, and stuff that we're coming up with. Um, and we also have CLEs, which is continuing legal education. Those are things that are required of attorneys. You have to have a certain number of CLEs in certain categories. Every 3 years, you have to continue to do these continuing legal education. And if our state attorney or chief assistant state attorney or our tri-union directors, if they become aware of issues that it seems like most of the attorneys in the office are not educated on, they will set up a CLE for us, and they will bring someone in to teach us different aspects or things that's going on. For example, everybody is using text messages now. They're texting whole conversations. They're texting about their relationships. People are even texting confessions. They're threatening each other via text. They're doing a lot of stuff via text messaging. And the law has not necessarily caught up with technology when it comes to those type of things. So I think it was last year or maybe the year before, they set up a CLE for us to learn about how to authenticate a text message, especially when you have these apps out here where you can pretend a text message is coming from someone, but it's not. So we had to have education and learn about case law and precedents on how to properly authenticate a text message so that it could be admitted into evidence in court. So those are ways that we do it inter-office. And it's also word of mouth. If I keep having an issue, the attorneys that I'm closest to in the office, that we eat lunch together, or we may have a group email, and I'll be like, well, this happened in court today, or this issue came up. Have you guys encountered this? What do you do when this comes up? As far as to the outside community, we participate in stuff. We participate in like 5Ks that go that support like different disabilities. We participate in I think it's backpack project is what it's called, and it gives school supplies to kids. A lot of us participate in the law week, which you go out and you teach civic lessons to elementary and middle and high school students. So you tell them about the inner working of the courtroom and the legal system and the different ins and out of the legal world.
And so also it says that my instructor and others have said that the six characteristics of a discourse community can explain how a discourse community functions, thrives, succeeds, and strives. These six characteristics are basically a common goal, mechanisms of intercommunication, providing information and feedback, the many genres that are in a discourse community, specific lexis or language, and many expert and members who have the knowledge to be able to be a part of this discourse community. Have you witnessed your discourse community move through these different phases at times?
I mean, yes, we move through these phases, I would say, on a daily basis, because on a daily basis, we're all going after the common goal, which is to seek justice by making the citizens whole in Orange County. Um, and our intercommunications, they're going on every day. We come up with issues each day, that you may have not dealt with or you may not be familiar with. So then you're sending emails and you're sending text messages, or you're going to your trial unit director and you're trying to figure out how to deal with a certain situation, or something might happen in court. For example, you may lose a motion to suppress, and you may think that the judge was wrong on their ruling. So at that point, you're using your oral communications to go and speak with more experienced trial attorneys to see, if you have cause for an appeal. And if you do, then you're going to move to written communication, and you're going to file a motion to appeal the decision that was made in court, and that'll move up and onward up the chain uh, to see if the decision was right or wrong. And as far as providing information and feedback, that's also going on, because every day that you're doing something, for example, if you do a trial, usually your trial unit director comes and watches you, or a senior attorney will come in the courtroom periodically and watch most of it, and they're going to let you know, I thought you did good on this. I think you need to work on this. You didn't make the right argument at this time, or you need to improve on this, or I thought you did a real good job, or that trial, there was nothing you could have done better. They're always providing feedback if you're open to it. You just have to be open and receptive to the constructive criticism that is coming your way, because that's the only way you can get better. And we also receive criticism, constructive criticism, if we're open to it, sometimes from the general public, because after a trial, you're free, if you want to speak to jury members after the trial is completely over and the verdict has been rendered, and they'll let you know, I thought that we needed to know more about this or that, and that's why the case turned out this way, or I really thought that you needed to talk about this, or I really wanted to hear from this particular witness. And that provides a lot of feedback from us for us. As far as the lexis and the language that we use, I mean, that's interchangeable. We use it every day, in and out of court, in and out of offices. We do it professionally, and we do it when we're just hanging around making jokes and stuff like that. It'll be terminology and words that most people wouldn't think are funny, or most people don't understand, but we as lawyers understand it. And then, as far as expert members, that can be on both sides of the fence. That could be a seasoned attorney, or that could be an expert witness that you're dealing with in the courtroom. Many people are experts in their field. We deal with a lot of people that work with the Florida Department of Law Enforcement, and those are the people that test the evidence for the entire state of Florida. So if you have DNA evidence, if you have fingerprints, if you have guns that you need to be test fired, if you need a crime, if you need I don't want to say that type of DNA, that might gross people out. If you need hair or anything like that examined or tested against something, we deal with those type of experts. We deal with medical examiners on homicides. We deal
out of law school, they want a job and they can get one at the U.S. Attorney's Office. What quality skills and looked for in them to even be a successful add-on to the U.S. Attorney's Office?
Well, we're looking for people that can first analyze cases. We're looking for people who can argue both sides of the coin, because you can't be a good prosecutor if you can't pick up what the defense is going to argue, and vice versa. We're looking for people who are comfortable speaking in public. We're looking for people who are in the courtroom. You have no control. Things happen. People say things. I'm pretty sure everyone watched Casey Anthony case. Everyone watched, for a better example, the Trayvon Martin case, and everyone was seemed to know how to adapt. You have to know how to think fast. You have to be able to research stuff. You have to not be afraid to ask your cohort, what should I say, or have you done this before? What do we do in this situation? Because things just come up quickly, 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 and you just have to be able to respond in an appropriate manner.
And so, as they're becoming immaculated in the office, what would you say would be some examples of some things that they may not need to, they're not expected to know, but when they actually get the job, they will be expected to know within a time frame that they are employed?
And the relevant law. Like I said, the law is ever changing. Motions are always being filed. You need to be able to look at a case and know if someone's rights were violated or not. You need to know, if the police officers follow the proper traffic stop and you want to search someone's car, there's a proper procedure to go through to be able to search that car unless the person, um, the owner of the car gives you consent to search. You're going to be expected to know those type of things within a short amount of time of doing certain types of cases. So each level that you move to, there's certain things that you're expected to know. Within a rotation of being there, within you being there, 6 to 8 weeks as you've rotated through, doing a trial week and a hearing week and an office week, and as you charge your own cases and as you've done initial appearances, they expect you to learn the things that are relevant with the cases that you're doing.
So, as you were a new member of the office, how would you say that you began to immaculate yourself to that level besides being in college and now actually doing what you said you wanted to do?
Research, 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 and asking other people. When I first started working in my office, I was working 12 and 13 hours every single day. I was taking work home on the weekend just to get past that learning curve, just to jump over that gap to learn the things that are relevant. When you're a new attorney, um, at the state attorney's office, it's a little different because when you're a new attorney, you're in county court and you're not just going up against other new attorneys. Defense attorneys can be practicing 20 and 30 years, and they're taking all type of cases, from misdemeanors all the way up to capital murder. So you may be in that courtroom going against someone that has 15 or 20 years, but you're still expected to know the same things that they know when it comes to this particular law and this particular case. So you just have to work long, long, long hours and not be afraid to ask what most people, I guess, would consider to be the stupid questions. Um, I did a lot of research, a lot of research. I have a lot of folders to this day because I didn't want to continue and repeat to do the same research that I have labeled with different issues. And I have like all the cases still in there, still documented and highlighted, and arguments still written up for certain issues. And a lot of that research I did within the first 6 months that I was a prosecutor.
And so, would you say that your transition from being in law school to actually being in a law office was smooth, or was it a challenge at first?
It was definitely a challenge. Um, I think that it's a challenge for everyone. I think that it can be even more a challenge with people in private practice because I was working 12 and 13-hour days to gain the knowledge that I needed to know, not because I had to work that to obtain my salary. When you go into private practice, there's something called billable hours, and 12 and 13 hours may not translate into 12 and 13 billable hours. You may work 2 hours and only be able to bill 30 minutes because that's how long it should have taken you to do that particular task. So it's very challenging because you're just, as soon as you're admitted to the bar and you're able to practice, you're just expected to know things. It doesn't matter if it's your first day on the job or if you're on your way to retirement. You're expected to know the law. You're expected to be able to articulate that knowledge. You're expected to be able to try the case that's in front of you. And that's just it. You're expected to know the answers for everything on that case, whether it's something you did or not. So the judge may be asking you things that happen when the police stop the individual. Those are things that the police should know because they were there when the stop of the car occurred, but you're expected to know it when you're standing in the courtroom.
And so, would you say that your transition was immediate, or did it take a little time for you to get used to how everything was run?
It takes a lot of time to get used to it, and you never really get used to it because you don't stay in the same courtroom. There are a lot of different judges, and judges are just like teachers. Everyone is different. Everyone has a different temperament. Everyone has a different style. Everyone has a different way they like to run things. People start at different times. Some people are more strenuous, are stringent, are stern on certain things or certain ways that things go in court. Some judges, they're on the bench at 8:30. They want you to be there. You better be there and ready to go. Others are there at 9:15, and they're willing to wait for you to talk to different people. It just depends on who you're in front of. So it's ever changing. It's the same thing with your trial partners. They're ever changing. Different people have different personalities. And your trial unit director, some people are more critical than others. Some people expect more than others. It just depends on the person.
And so, do you feel like you're still in the transition phase, or do you feel like you're used to what you do now?
Right now, I'm used to it because I've been in this spot for a little bit, and I've been under the same unit director for a while, and I've been with the same trial partners for a while. The minute I get promoted, it'll be another transition. I won't be used to it, and it'll be difficult again.
And so we had recently talked about how newcomers, how they can get a job at the U.S. Attorney. Um, is there any way that someone new can come into the attorney and just jump to the top, or is it every time a newcomer is going to take them a long process to get to that type of level?
It's gonna take them a long process. The only way that you get into a certain position is if you have experience. So in that rate, it would be you're a newcomer to our office, but you're not a newcomer to the profession. You're coming from another state attorney's office, um, or you may be coming from the statewide prosecutor's office, or you may be coming from a public defender's office, or you may be coming from private practice where you did defense work. In those situations, then yes, you would not have to start as a misdemeanor attorney because you have the experience and the courtroom knowledge to start at another position. If you are coming from private practice, the only way in private practice is all you've ever done, like civil litigation. The only way I see you not starting off in misdemeanor is probably if you want to do economic crimes, which is fraud based, which a lot of civil attorneys are probably very familiar with. Um, it's like embezzlement and unemployment stuff and things like that, things that are both criminal and civil in nature. Other than that, yes, you would have to start off, down towards the novice level, the beginning level.
And so, how do you feel as if they can function and operate with the discourse in your discourse community?
You just have to be open. You have to be able to adapt, and you have to be willing to learn. Because that will cause your cases to change. Right now, it's a big thing where they have marijuana on the ballot, and medical marijuana at some point may be legalized, and that's going to change the law. That's going to change what people get arrested for. That's going to make different consequences for different things. So you just have to be open and willing to learn and ready to learn.
Being a prosecutor, what do you feel as if the discourse that you use in the office has helped you some way in real life?
It has helped me be able to master. It's helped me to be things to people because jurors come from all ethnicities, they come from all, and you have to be able to basically break down a solid concept to them and have them believe it. And that's a tough hang in, I guess, groups or cliques or whatever you want to call it, as students, as adults, as employees. We hang with certain groups, and most of us are alike. We may be different races or different ethnicities, but a lot of us grew up, came up in the same same sports, or we're dating the same type of people. We have the same major or something of that sort. But when you're in a courtroom and you're explaining things to a jury, I mean, a college student to I had a psychiatrist that worked at the VA. So those are two completely different people that you're trying to explain the same concept and have them believe the same concept. at the same time, using the same words and the same examples, and that's a
You feel like the language that you have to use in the courtroom has that helped you be able to better communicate?
me to better communicate with others, especially when it comes to jury, better understand other people, because you hear a lot of perspectives and you hear about a lot of different backgrounds. It helps you to be able to get your point across to people from different walks of life.
And so, in a sense, has being a part of the U.S. Attorney, has it somewhat grounded you?
I mean, I don't know if it grounded me, but it definitely has helped me to grow as a person. It's helped me to learn more about different nationalities. It's helped me to not be as judgmental, to be more understanding and more empathetic and compassionate to others and where they come from and the things that are important to them and the things they may be dealing with or suffering with, and how they react to things too. Because people don't always react the way you think they should or way you would expect someone should to a certain situation.
And so, although it might not be something that I'm interested in, what would you say that learning from your discourse community?
Um, it can help you to be able to explain yourself. It can help you to be able to effectively communicate in written form. Like I said, we do a lot of writing. We have to break down a lot of facts behind it. And it could just help you overall as a communicator with your interpersonal skills and your intrapersonal skills.
Okay, this has been the second half of my interview for my class for ENC. Basically, delved into the idea of how genres and mechanisms of intercommunication and how discourses are different from each other, and that within a discourse there are some things that some people who are seen as outsiders, you may have sometimes you may have to keep outsiders out and sometimes keep insiders in. Thank you.